Hey everybody, it's Pierre and Dr. Arnold. How you doing, James?
Good morning. Very well.
So, I know a lot of you are asking, or maybe I don't know hell if you're asking or not, but I don't have my little tunes as to roll into the Bedard's unofficial podcast. And mainly that's because we're going to a more YouTube event. So this is probably best watched on YouTube, even though it's still available on all the other podcast channels, and we appreciate our viewers. So
Excellent.
today's episode is actually, James, I've looked back and I think this has got to be the fourth episode on the Sheppard case.
And we're doing it because it just stands out. You had contacted me, and immediately I saw what you'd contacted this decision that came up as one of the front page stories in national CBC News. So we're doing it because it stands out and it's important.
Well, also, so the Supreme Court delivered an immediate decision after they heard the case back in January, I believe. And the reason this came out in the press is because the Supreme Court finally issued its written opinion. Nothing odd about that. It happens all the time. It takes time to write things up, and this is how justice works in the free world, which today
I
is
think what
Canada.
happens is they probably write it up, and then they have all these judges, and each one of them probably has to read it over and say, "Yep, that makes sense. I like that." So it
Well,
probably
if
takes them months.
they do, if they approve or vote for it,
Yeah.
and or they, like in our Supreme Court, me being in the U.S., they'll have well, even here, they'll have minority opinions. People will see things a slightly different way. In the legal business, a minority opinion that's smart is called dicta, which
Oh,
means
okay.
somebody will dig up the dicta for another court case and see, Justice blah 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 said this
I don't
in
think
her
we
dicta.
didn't have any of this on this one. This was like all the judges were like, we understand this. They may have all contributed to the draft of what was finally written up, however. So that's what took the time, eh?
Well, this was not a contentious decision,
Yeah.
to say the least. So let's talk about it. So R.V. Sheppard, and for all us U.S. people out there, James, what does R stand for?
That stands for, well, currently it stands for Rex, which is Latin for king. When it was Queen Elizabeth II, it was Regina. So that's Regina is a queen and Rex is a king.
You got to hand it to those lawyers figuring out an easy way not to, redo all the documents.
Absolutely. And I mean, it's really interesting in Canada, right? We have, even though, the royalty is really not part of governance, but we always talk about the crown. They'll have the crown prosecutor, the crown attorney. And it just means that's the person that is running things for the state, for the government, for the province. And in
So
this case, SCC, Supreme Court of Canada. So we're talking the highest court in the land.
exactly, and this case will forever be known to law students throughout the Dominion. Well, you're no longer a Dominion, but
Right.
throughout Canada as
But it is
2025
interesting. They do
SCC
refer to,
29.
I have seen that they do refer to decisions in other parallel jurisdictions. They have referred to decisions from Australia, New Zealand, and the UK and Canada. They're not,
Yeah,
they don't dictate, but they have information that they think is that was well written. We'd like to read that.
you know what? That's particularly frowned upon in the US.
Yeah.
In fact, there are very few decisions. There's actually a Beauville decision that is cited, God knows for what, but there was an English case about a pub and the stocking of Bovril, a fine product. If people don't know Bovril was sort of dehydrated cow
Yeah, it's
parts.
dehydrated, sort of bad soup. The
But
kind of stuff you got on the kind of stuff you got on the canoe trips.
it helped you think you were getting protein in you.
Yeah. Yeah.
And fortified with soy pellets, you were.
There
So the
you go.
following presentation is really a summary and our own opinion, our own personal opinion about the Supreme Court of Canada's ruling in the matter of Paul Sheppard. Now, the date of judgment, this case is actually quite fresh. Today being the 29th of September, it was done the 26th. The court, of course, was the Supreme Court of Canada, who heard an appeal of a judgment by the Alberta Court of Appeal. And an overall subject to this really was, why did the Supreme Court take the case? Because it had a lot to do, or it's going to remain important for the sentencing of historically sexual offenses.
Yep.
James, what do you think of this?
Well, this was a situation where you have an old case from a teacher with good legal representation, former headmaster with good legal representation. It goes through the Alberta court system. He gets sentenced, it gets appealed, and the appeal drew attention. We don't know exactly why the Supreme Court chose to hear it, but we can assume that there was probably several things. One is that the Crown prosecutor in this case decided to put it forward. But the second is there must have been a list of things that they looked at and went, oh yeah, we need to talk about this. We probably have been waiting for a case like this because we want to say stuff.
You're thinking too much as a clinical psychologist. As sort of a half-assed lawyer, this case really was about, what was a case that was all about what the hell do we do about Friesen? We're going to talk about Friesen coming up.
So I thought it was I thought it was about what we're going to do about Sheppard. But
there's that. But you know what? If you're and this is you just brought up a good point. The abstraction of between the victim and the criminal, by the time this gets to this high a court, the rationale for the court taking on the case is completely different. And I think the case really the court wanted to send a message that the appellate court should only intervene if there's an error in principle that impacts a sentence, meaning they looked at the Alberta court's position and said, guys, what are you doing invalidating a jury trial? They emphasize,
and is it not that we're talking about opinions of judges versus a judge, the decision was made, it gets appealed, and some people think that they have worthy opinions and they decide to exercise and state those opinions and change a sentence.
Exactly.
That's what
and a jury, especially a sentence, all the judge did really, the judge did not determine Paul Sheppard's guilt.
Right.
The jury did. All the judge did was really look at the evidence, look at the historical precedents, huge deal again, and made a decision. And the court sat with her. The Supreme Court sat with her. She made the choice that historical offenses need to be gauged in contemporary prisms. She did.
Right.
The
Sheppard needs to be looked at. We don't cast ourselves back in time and go back to 1985 or 1992 or whatever date and think about it. How would they have thought about it back then? No, we think about it as we think about it today because we have learned things, we're modern, and we're not going to go back in time and pretend that we're in the olden days.
And the decision really aligns with the current societal views on this stuff. I mean, in the back of my head, I was thinking, Mealy, Kevin Mealy, the guy who was busted for things worse as bad,
another
just
teacher,
crimes against children.
Mr. Mealy, a teacher.
Yes. An assistant headmaster, I believe. And he only got 2.5 years.
Right. And he got 2.5 years because they were doing things differently back when, and they were also interpreting things through a different vision, a different, as you said, prism or lens or way of viewing things, right?
And the court said enough. I mean, I
Well,
get the sense, right, in terms of the Supreme Court said, no, you gotta, if you're going to do this kind of crime, and you know what? It reflects what people think. I mean, nobody, what's the worst crime you could possibly think of outside of murder? Even then,
it's this.
rape,
It's this. Yep. Yeah,
this.
it's this. Yes, no question.
So, 2.5 years, I keep thinking that just, there's no justice there.
Well, if you think about, so you've got 2.5 years, or you've got, in this case, we've got six years. Somebody who has experienced sexual violence is potentially dealing with a lifetime.
Yeah.
And
Oh,
let that sink in. And
don't.
let that sink in. Let that sink in. Lifetime versus 2 years or 6 years.
So here's some key facts. The offender was a teacher at SJSA. His offenses: sexual interference and invitation to sexual touching in 1993, 1994. The victim, a very brave person who was a grade 7 student at the time.
Yeah.
That can't be ignored. The fact that they stood up and said what needed to be said. The details, reading, I got to tell you, when, we can all talk about this in a abstract manner.
Yes.
But when you read the Supreme Court decision and it lays out and says, this is, by the way, none of these slides are made up or this is all extract.
This is a factual summary.
Decision. Yeah.
It's a factual summary.
10 times.
So let me talk. Can I just say a little bit? So when we go offenses, sexual interference and invitation to sexual touching, what this means is the offender, Paul Sheppard, decided to start sexually touching the genitalia, the personal private parts of the grade 7 student, okay? Decided to do that. And then said, okay, now you touch me. And touching, let's define touching. Touching isn't just, I grabbed you with my hands. Touching means you did all sorts of creepy sexual things to a child, and you had the child do the same back to you. We're talking everything you can imagine that people do in sexual activity, okay? We're not talking about, I looked at your penis or something. We're talking about touching.
The detail was,
I don't want to go into it too much, but everyone knows what sexual activity contains. Just think about all the possible sexual activities, and all I'll say is yes. And so the adult did to the young person, and then got the young person to do it back to them, made them do it. And also understand that at St. John's School of Alberta, at all 3 St. John's schools, the teachers had a lot of authority, and they had the threat of physical violence by swatting, paddling on the backside with a wooden paddle. So you've got the context of sexuality with this other role of heavy discipline. This just makes it so bad. And realize, many people watching this podcast will say, well, I was a student there, I understand that. Yeah, you understand part of it, unless you had the sexual part done as well. There's this ominous kind of, okay, we're doing the sexual thing, and if you don't go along with it, maybe I'll hit
you. Well, you were going to get hit anyway. It wasn't
right.
But
I don't could you be hit?
The swatting thing. It was.
Could you be hit by this? Yeah. Could you be hit by this charming teacher because you didn't go along with repeatedly because you didn't go along with the sexual behavior, the sexual touching? And might you, if you went along with the sexual touching, the sexual interference, the sexual assaults, if you went along with that, would it mean that maybe you didn't get disciplined with the paddle, with swats as much in other contexts? Who knows?
You know what? I think we're giving the pedophile Sheppard too much benefit of the doubt, because I got to tell you, the more I think about this shit, the more I think, nah, this isn't normal. This was never normal. This man was drawn, and we'll get
We'll
into
get
that
into
a little
that.
bit.
I will say about approximately 10, you know, 10 instances, who knows? Like, he
That's what
doesn't
was cited.
remember. He doesn't, yes, that's what's cited. He doesn't remember. The student that he assaulted doesn't remember. You know, the precise, was it more? Yeah, it's usually more.
Absolutely.
That's summary.
Oh,
That's
no
my
shit.
summary. And I'm going to refer again, in a previous podcast, I think I referred to some old research now from the 1980s, but really difficult to do. They went to incarcerated sexual offenders, and they found that the courts generally cited 1 in 6. So I go from, we have 10 instances cited. What's the high mark? I don't know, maybe 60. Who knows? Maybe more than that. We don't know. But 10 is just all that they listed.
So after a jury of his peers convicted him of, these crimes, he was sentenced by Deborah Youngsworth to 6 years incarceration. And he, by the way, what's not in here is he first appealed his conviction. And
Right.
the Court of Appeal rejected it. And then he appealed to the Supreme Court on his conviction. And they refused to hear it. They refused to even hear the petition. So that's something that's missing in here. But on
And
this, he got the
I do
Court
want to
of
make a
Appeal.
comment about that. I wonder how much it costs to launch an appeal and then launch an appeal again to the Supreme Court. Like, somebody's funding this. I don't know. Did Paul Sheppard all of a sudden become a millionaire?
It's either Elon Musk or George Soros.
Oh God.
One or the two.
let's not do conspiracies here, but there's some substantial funds. I'm
It's a lot of
not
money.
familiar with the Supreme Court, but I have seen that, a criminal jury trial can cost 50 to $100,000 easy. I imagine appeals cost at least that. So
Trials have to
we've
be
got a
done
lot of
right.
money. Yeah,
Trials are
we've got a lot of
produced.
money being spent here. I'm not saying it's $1 million, but it's certainly.
So anyway, let me go through it. He appealed again. And this time he appealed the sentence, and he got an Alberta Court of Appeal to listen to him. And the
Alberta
Alberta
Court of
Appeals.
Appeal.
Hmm?
Alberta Court of Appeal. Yep.
And he said the Court of Appeal 2-1 said there were insufficient reasons for the factual findings, and the judge didn't consider pre-Friesen sentencing jurisprudence, i.e., she did not think about the crime occurred in 1993. She did not consider, like judging him as if it was 1993 and giving him a
Right. So if he had
term
been charged,
that he would have gotten.
in 1993 or a year or two later.
Yes. But after Friesen, things changed. So the
Right.
Alberta Crown Prosecutor, God bless him, sought leave from the Canada Supreme Court. He said, okay, maybe, a reduction to 3 years and 11 months. That's a, 2/3 reduction in sentence.
Yeah.
Yeah. I mean, I don't think he looked at the time. They look at the principle. And the principle was, could Court of Appeal 2-1 change the sentencing of a juror backed by a jury? It just didn't sound right. In fact, the court, one thing the Court of Appeal considered were all the letters written by St. John's School of Alberta folks.
And this is amazing to me. This is amazing to me. When somebody has done something illegal, and then you have a bunch of people saying, well, I know him. He's a good fellow. He's a good guy. I like him. He never did anything weird in my presence. Good heavens. That's not evidence. That's just an opinion about how your contact with the individual happened. I can't imagine how that creates a lot of weight. And we do have some pretty impressive people having written some of these letters, right?
A sitting Alberta judge. I don't know if he's still sitting, but he was the father Alan Fradsham. I mean, he was in he's in some of in the Court of Appeals, I believe, his letters. But, he believed, I received 2 emails from St. John's School of Alberta people telling me no way, no how that Mr. Sheppard could do this. So I mean, he snowed certain people.
Well, and
He preyed on certain people, and he just bullshitted others. I know
I'm
it.
going
I
to
do it
say
all the
something.
time.
I'm going to say something as a psychologist just to describe something general. There are those who do, not overtly violent sexual offenses. They're not actually, beating people up before they sexually assault them. There may be a sense of violence, an ominous sort of sense of violence can occur, but we have a whole group of sexual offenders that are what we call pro-social. They have good social skills. They know how to talk. They're charming.
Lawyers,
They
for
pull
instance.
they pull off sincerity. I wasn't going to say lawyers, but they pull off sincerity. They pull off trustworthiness. They know how to walk the walk and act the act to fool a whole bunch of people. So I would say, respectfully, those who wrote letters, they were either completely naive or completely snowed or a combination. He was a charming fellow. I mean, you look at his picture, you look at the pictures that we have of him at the school and in some of the media. He looks like a charming fellow. He's smiling, he looks affable, looks pleasant. You can't judge a book by its cover, people. You
He
can't
looks
do
a
it.
lot like Mealy, and Mealy looks a lot like Bob Oldenkirk as Saul. As I mean, he looks like Bob Odenkirk with the big fucking glasses, and
Right.
I'm just I'm sitting here listening to you, and I'm just disgusted. I mean,
You
really, I'm just
cannot,
fucking
you
disgusted.
cannot, you cannot read into what the person tells you about what they didn't do. And
So anyway,
you can't take their good contributions in other areas of society to signify, we talk about Mussolini made the trains run on time. Doesn't mean
but
he wasn't a good guy, that he
I'm
was a good
president
guy.
of the United States.
Yeah. That's a whole other podcast. Okay.
Look,
So,
Deborah Youngsworth, I'm just gonna,
yeah.
she's the main person on this. She found him guilty and got him to 6 years. Like I
And that's
said,
pretty standard from my,
no, she
I'm in,
didn't go outside of the rank, right?
no,
I mean,
I'm in Saskatchewan. I understand that that's a fairly standard current. I'm, in my opinion, I don't think this is enough because those who've suffered sexual offenses go through a lot more. But this is 6 years, and it's standard within the current sentencing guidelines.
in Canada, it wasn't. Like I mean, I was shocked at how
In the
little
in
Mealy
the
got
past, right?
compared to what people in the U.S. Because in the U.S. it's just much more hardcore, and it's usually
Right,
federal.
right.
And not state, and federally they get you, because you use the internet and stuff. It's just bad. It's just not good, not good, not good, not good. But anyway, we've rehashed some of this, but bottom line, the Supreme Court restored the original sentence. Now, their decision, the key issues, were the sentencing judge's reasons sufficient? I don't know.
And they said yes, and they said yes.
And they said yes, and they were. Did the judge err by not considering pre-freezing case law? Absolutely not.
And so what this means is that we started taking sexual offenses against children much more seriously. There was a royal commission called the Badgley Commission in Canada, the Badgley Royal Commission in the 1980s that went through what the epidemiology of sexual misconduct and behavior towards people were. So it went through data saying how many people, what percentage of the population is subjected to sexually inappropriate behavior that harms them. And it has spin-offs all the way down through life, affects their income, affects their health status, makes them die younger, affects their relationships, affects their children, etc. And so what happened is there was a sea change, a big change, as we were moving into the 1990s in Canada to consider that sexual offenses against children and against everyone, Anyone who's affected by sexual offenses must be taken much more seriously. And those who are interested, you can go and look at all the royal commissions that are available on the internet. It's called the Badgley Royal Commission, and it's fascinating and horrifying to read, because we were finally turning a corner and saying, we're not going to accept that children are simply playthings for adults who want to get their jollies.
How can the appellate, by the way, the appellate justice is retired now, the guy who wrote the majority opinion, but how could he possibly think that way? I just don't get it. I just
Well, as you said, there was even a character reference from another judge in Alberta. So it may be that the Alberta court system, Department of Justice, Alberta court system, however they're configured there, is dealing with some old, I'll just say fossils who need to get the hell out of the way for younger people who understand modern and how we're dealing with things today.
Pierre's random factoid, Youngsworth replaced him on the bench. So Youngsworth actually took his slot on whatever the Superior Court bench in Alberta was when he moved to the Court of Appeal.
Good heavens.
The main guy.
Boy, what a small
It's a close
world.
community.
Yeah, not a lot of people in Canada in some jurisdictions.
Well, like what? Hell, you're in Saskatchewan. It's amazing. You guys have running water.
Yeah, I know everyone.
I know you have Sutters, but that's about it. Anyway, his decision, look, the sentencing judge
and by the way, Pierre, I don't have running water.
You don't?
No, we have to fill up. We have a water tank in the crawl space underneath the house. So no, I don't have running. We're rural Saskatchewan. That's how it works.
Even a blind pig finds an acorn once in a while. So I made a guess. The sentencing, the court found obviously that Judge Youngsworth was sufficient in her reasoning. She applied the contemporary principles by giving him 6 years, and the Court of Appeal erred by intervening, which is the whole point of the case. They should have just stayed the hell out.
Now, I don't know how that plays to others, but it looks to me like it's a big slam against the Court of Appeal. Like it's not just, we kind of disagree. It's okay. No, you shouldn't have done this, guys. People, like, no way.
Well, it took a while for the Crown to actually, in fact, it took a while for them to file for leave from the Supreme Court, because
I think what it is they have to be really careful, right? They have to do it right.
Well, they got to do it right. And they have to have a reason for doing it. So the principles, and we talked about this before, right? Apply contemporary sentencing principles.
Can I just say something? I just want to stop for a second.
Yeah, go ahead.
The prosecutor that moved this forward to the Supreme Court, we saw him do his presentation. They were doing it virtually, so we attended that virtually, and were able to see him do his presentation to the court. Spoke so well. I was very impressed, and reading the documents, very impressed with how that was written.
Well, Matthew Grenier.
Yeah.
And when I communicated with him after the original Court of Appeal decision, they weren't sure they were going to go for it. They weren't tipping their hand either way. Like you said, Jim, it takes forever you really got to be sure about what the hell you're doing. Grenier is great. He was fantastic.
Well, for a prosecutor in a situation like this, you've got many cases, thousands of cases every year, and they have to pick and choose what they're going to take. He had to make an argument to his Department of Justice colleagues, the court system, the Chief Justice, whoever all those people are, make an argument, write it all up, be very concise about why he's doing this and the principles thereof. Did a real bang-up job. I was very impressed.
And they look at it, they reinforce the key precedents. Now, precedents in legal, I mean, when you look at, people are going to be talking about R.V. Sheppard as a precedent.
Forever.
Yes, that's going to be there forever. That's not going to change. And it's going to be there every time Friesen comes out.
Right.
We said it, we said it.
And so Friesen is just another person that did sexual offenses. And so is Lacasse.
Yeah. And every time that these come up, Sheppard will be added to it.
Correct.
As the guidepost for how, precedent at least in certain countries, court precedent is followed. We
Well,
used
and
to
I think
follow
I
it.
think I think what will happen with this is young people in their university courses going to law school will know about these decisions. It'll be on their
Yes.
exams, and they'll refer to them, and they'll write up their. And when they're out practicing, they're going to be referring to them and raising them, and everybody will know what they are.
So there you go. It is immortal in that sense. So
Right.
that's sort of, it's frightening, but I mean, if you're a legal geek, it's cool.
I'm going to say something, by the way. The way these are listed, so to just go back a slide just for a second, you see how this is listed? 2020 Supreme Court of Canada 9. That means it was the 9th case in the year of 2020.
You didn't even go to law school. That's
Yeah,
shit
64.
trivia that I know. I
Well, I
just
mean,
never
somebody's
said.
gonna ask, like, what is that?
No, that's a
So I
good
thought it.
one. That's, by the way, that's like the first thing you have to learn in law school, because
Well,
you have
I've
to
done.
figure out the year, the jurisdiction, and where the hell's the case.
I think
Uh,
I think it's known by the people who are watching these podcasts that I did testify in all levels of courts in Saskatchewan, multiple, hundreds of times. So I'm quite
ugh,
familiar with how some of this goes. So it's not that I'm any legal scholar. I am not a lawyer, which
you know,
abbreviates I anal, by the way. I am not a lawyer.
neither me,
Sorry, I just had to throw that out there. This is
but
heavy stuff. It's always worth having a bit of a sense of humor when
yeah,
we're
those
talking about some.
Saskatchewan cases of cattle running loose, into your gardenia garden is like really, I'm sure
No, it's all
you testified in those.
we're right back to water. Everything in Saskatchewan is about somebody draining water onto somebody else's field. That's what it's all about here.
So their analysis, the analysis is very good. This is just a summary. The reasons were clear. Um, the appellate court tried to like pigeonhole
Yes,
Youngsworth into places that you're thinking, what the hell? And they made up their logic
right.
almost. Um,
Well, and this again gets us to, you know, the connections and the understanding and the current political climate and everything. It just makes us wonder about things. Alberta is in a particular spot right now where they're kind of articulating things in odd ways from the premier's office all the way down, and you just kind of wonder about everything in that province right now.
well, they're the closest thing to Fahrenheit 451 with all the book burning stuff, the book banning,
Oh, and
not burning.
sorry, since you bring that up, another aside. The Edmonton Public School Board um, just went through a whole list of books and said, okay, well, according to what the government of Alberta says we have to ban, here's a list of all the books we're going to ban. And now, of course, the libraries across Alberta all have to have special sections because everybody's coming and going, can I see all these banned books that they're not allowed to read in school? Yeah, we had to get a special section. And I understand bookstores are doing the same thing.
That's
Here's all the
great.
banned books. It's talk about an own goal, as they say, right?
Well, no, but don't you think that there's somebody at the Board of Education who said, oh, this is great. Let me do a list. This will show these sons of bitches. And then they're going like, oh shit, they're taking me seriously. I mean,
Well,
I understand.
yeah,
Handmaid's
and
Tales on this.
yeah, I know, and I just think of, oh my goodness, it would be nice if people were just a little bit more sensible, but anyway,
They're
oh,
not.
I
They're,
know,
you're
no,
bad. Well, you know what? It's a bell curve.
there you go.
It's just a bloody bell curve. But it's just so many people, and there's just, people at both ends.
There
Um,
are, there are.
so, we're back to Friesen. This is
So, so,
interesting.
so, so, so explain. Are we going to explain Friesen here? I think we should just
Go
explain.
ahead, but I want to talk about the pickup on myths and stereotypes, especially from our good friend Angela at
Right,
the
right,
Raoul Wallenberg Foundation,
right,
who came in as sort of I guess in the U.S. it's an amicus brief.
right.
I don't know exactly. I think it was like a factum in support.
Right.
of
They
the government.
generally have gotten. When I've seen these things, they just say friend of the court, which is exactly what the
Yeah.
Latin translates to. Basically, it means somebody who's not centrally involved can submit something to the court because they have something important to say, and the court considers who's allowed to say something and say, yeah, you actually do have some stuff to say. We're going to allow it, because the point of trying to make decisions in a court and in a democracy is you need to hear all the points of view to understand everybody. It's not a consensus situation, but let's hear what all the sides are. So the Friesen thing is really important because it said you cannot go back to 1920 or 1962 or whatever year it is and say, I'm going to consider those decisions and I'm going to outweigh current decisions based on that. What they said is, we need to move along. We've learned a whole bunch of things about how sexual crimes, how sexual assaults, whatever the specific charges are, how it affects people. And we're not going to go back in time when they didn't know some of the things that we know now. We are going to be contemporary, up to date, and modern about our understanding. So that's what the situation with Friesen, as I understand it, that we have to go with contemporary and modern understandings of things, and determining to not even mention old, outdated decisions is okay. We shouldn't be going back in time.
Here's the example I have, though I don't know that it's a great example. All of a sudden, in 1930, it becomes illegal to marry your first cousin.
Right.
But before 1930, you could go for it. First cousins were fair game. Don't ask. Maybe this is a bad example.
No, it's a good example. It's a good
cousin.
example. It's a good example.
You marry your first cousin in 1970. And you say, screw you, it was legal. Or you can sentence me to what it was when it was legal. That's sort of free. Is that Friesen, or is that sort of an example?
That's sort of the example, yeah. And of course, the reason you don't marry your first cousin is because if you have genetic problems within your genes and you combine it with somebody else who's too closely related, you have a chance of, oh, I was carrying a gene for Huntington, cystic fibrosis, God knows what. Now we are going to see the full expression of that disorder, or the disorder wasn't even going to be seen because there wasn't the genetics to cause that to emerge.
Yeah, well, anyway. What if you're... I won't debate first cousins. The reject.
Well, this is a problem with the reason people would marry their first cousins family. To keep the land. Well, they'd keep the land and the money in the family versus, marrying a commoner like, what is it, Prince Harry and Meghan, who now live near your neighbors down there in California. Right?
They're good that Meghan's, they mix it up. I think it's good. I mean, the thing, the British have the whole royal family network
is inbred.
Europe had issue. Yeah.
Well, all sorts of. Queen Elizabeth was cousin to Prince Philip, was she not?
Wow. Okay, so that puts Friesen in a different light. To me, when I hear Friesen, I think of Jeff Friesen, who was a winger for the San Jose Sharks for years. But
I think of rural Saskatchewan, where Friesen is about as common as the name Smith and Jones. They're everywhere. They're everywhere. It's a good Mennonite name from rural Saskatchewan and rural Alberta and rural Manitoba, Ontario. It's just a very common name.
The media picked up on the myth and stereotype issue.
Now, say some more about that. You started saying who contributed all that.
Well, Angela Marinas, who's with the Raoul Wallenberg Center, did a factum as a support for a friend of a court, but they really, they targeted the fact that the appellate court really was looking at myths and stereotypes. Like one thing they said, the victim was in therapy. So how the hell could they actually remember what went on? And then they did things like they started, dealing with the number of activities or the number of guilty verdicts that he had, even though the number of actual instances had to be way further than 10. They started looking at the 10 he was convicted of and narrowing that down into different types of touching. Like they actually looked at it and said, well, this was out on, he touched him. I'm sort of making this up. I don't have it in front of me, but he touched him on his clothes.
Right.
And that's less egregious than touching his raw penis. So it's
and
not
I'm
really 10 penis touches. It's like 3 clothes. And, so
we don't keep scorecards of this
6
stuff.
years. You should get 6 years. You get 3 years, 11 months.
You get 8 months for each, a touch over clothes and 12 months for each touch of penis. It doesn't make any sense. I will say something, by the way. This idea of remembering, they didn't remember and then they went to therapy and they remember. That's not how it works. How it works is, as soon as you start talking about what happened to you to someone else, that's now a conversation, and you start losing control of this. So you mention it to somebody, and that person thinks, they've talked about it, I'll bring it up another time. And now you lose control of that. So people who've had sexual things happen to them, sexual offenses happen to them, very frequently, when they know exactly what happened, they just don't bloody well talk about it.
Well,
they don't want it brought to their mind all the time.
But they attack the fact that how could he be credulous as a witness if he was undergoing therapy, and which is
that's nonsense as well.
And that's nuts.
And what the therapy does, is allows the person to begin to be able to talk about it, but do the emotional control aspects of, I'm now able to talk about it and I'm not an emotional wreck after I do it. It helps you control what's happened. You hear the terms emotional regulation these days. That's what a lot of therapy is. It's ability to talk about things that you couldn't ordinarily talk about.
You're missing my point. They attacked him.
Yes. I'm not missing the point at all.
Because they were in therapy. And because they were in therapy, how could they tell the truth? How could they they're less human. It was like an othering. That's what got me.
You've also got them assuming then that therapy is leading people to talk about fantasies that aren't true.
Maybe. In the back of that, they don't state that in their opinion, but that's no doubt in the back of their minds. I agree with you there. But they don't. So we can't be overt about that one. That's a tough one.
No, but I think these things about what therapy is about. It's about helping people deal with things that they can't deal with in any other way. And so people go to therapy to talk to knowledgeable people who will talk them through and allow them to integrate their understanding in a way that doesn't destabilize them all the time. Helps them get their emotional and their cognitive, their ability to think, and then their relationships with others and their behavior everywhere kind of in line with, okay, now I feel like I'm kind of together again. I had something that really bothered and destabilized me and freaked my life out for a while. Now, and even when you go to therapy, so you get put together and you're okay, but there'll be a time in the future where you're not. That's very, very frequent with individuals who've had sexual offenses done against them when they're kids. So anyway, complete misunderstanding about therapy. I'm digressing a little bit, but they had so much mythological nonsense. And so we had Angela, the very bright, well-informed lawyer from the Raoul Wallenberg Center. Raoul Wallenberg, named after the fellow who smuggled, I don't know, hundreds, thousands of Jews out of Nazi Germany.
And disappeared.
And we think he was probably, somebody probably got to him and, put him in an unmarked grave before the war ended. But he was a diplomat who smuggled. So somebody who advocated and is a symbol of advocating for human rights.
And it was interesting when they came onto the case, because I was sort of following the Supreme Court docket. I was thinking, oh shit, did this scumbag get this foundation to speak up for him,
Yeah.
like some kind of prisoners' rights type thing,
Yeah.
right? Like
Absolutely opposite. Right.
and then when we talked, I realized, oh no,
No. No.
they're good guys here, and they
Oh, good
were.
heavens,
Angela
yes. Yeah.
really,
Yeah.
I mean, she was cited, I believe, in the
Yeah.
by the Supreme Court. They very
Yes,
much
she was.
and she practices in front of the Supreme Court a lot.
So what she did, just so those who haven't followed all of this, what she did is she went through, when they say myths and stereotypes, what this is there's common ideas that have been passed down over the centuries and over decades about how sexual offending and victim behavior occurs. And there is actual scientific data to say that some of this isn't true, and that these are actually the replacement
because it
facts.
isn't true.
Because it isn't true, and let's think of, I'm going to give a parallel example. At one point it was thought that disease arises from being unclean, so everybody had to wash their hands, and they used carbolic acid to sterilize things, and they thought it was from dirt. It had nothing to do with dirt. It had to do with germs, bacteria, viruses. So you update the knowledge. And so that's what happened. Angela updated the knowledge and summarized things nicely, and did a whole bunch of work that made the job easier.
She did. She's definitely helped things along. So I wanted to talk about reincarceration.
This is startling. This is startling as
I
hell.
don't focus on the shit that came out in the parole board about his prior convictions. That's icing. What I thought was interesting was he wanted new evidence in.
Right.
He wanted to show what a good guy he was, how the parole board in Canada, actually, you should talk to this, how the parole board works in Canada, because I got to tell you, most people listening to this are old boys are thinking, how the fuck did he get off this quickly? Because even though you get 6 years, 6 years is not really 6 years in the justice
So what
system.
you have in Canada is you get 6 years. That means the federal government, the Correctional Service of Canada, has control of you for that period of time. And what they're interested in is rehabilitation, and they know that most offenders are not going to spend the rest of their lives behind bars. So they want to reduce the amount of actual in-jail incarceration time and put people back in the community under day parole, which is a lot of supervision. You have to stay in a particular place. And then full parole, you're reporting to somebody in the community. So what they do is they do a whole bunch of assessments. They do psychological assessments and statistical assessments that are very well done. It's very much like the insurance companies deciding how much to charge people for premiums. They do a pretty good job of making profits. The parole board is in the business of estimating risk. And so before the 6 years is over, at what point can we let this person out such that they'll be reintegrated and they will not offend again? So when they say the respondent assessed as average risk for recidivism, what that means is they did all of their assessments. And they said, based on our profile of all the sex offenders in your category, the kind of offenses this guy did, position of authority, teacher, offending against children, etc. They assessed him as average, and they said, okay, we're going to treat you as an average offender, and we're going to look at the amount of sentence you have, and we're going to decide to reduce your in custody, in jail sentence and put you into a supervised community kind of setting because of your average risk. It has nothing to do with anything else. It's them just saying we need to reintegrate people. So that's what they did.
And parole is really two-phased. I believe the first phase is day parole, where
Correct.
you sleep at a halfway house or something. Right. And the second phase is full parole.
Correct.
Where you have to report in, I'm sure, but you're free to do whatever the fuck you want.
Now
Well,
they have
Mr.
other provisions. They have other provisions. When they think that somebody is highly dangerous, they can detain them and not give them the normal parole dates. So when I was doing
But
parole assessments, and my information is probably up to date, but it could be possibly outdated. If somebody has done a non-violent offense, they've done, they're breaking into houses or something, and they've got so many of them, or they're doing, fraud or whatnot, they will begin to assess for day parole at 1/3. So if with a 6-year sentence, they will begin to assess that at 2 years. If somebody has done an offense that's harmed somebody, a violent offense, they will have that date becoming half the sentence.
so he did 3 years maybe and
Right.
was out and day parole. And I believe he was on full parole when this case was being heard.
So he was
So,
assessed. So if it was 3 years, that fits with our understanding that offenses that harm others, violent offenses, are considered for parole, day parole at half the amount of the
but remember,
incarcerated sentence.
half of 3 years at 11 months now, not half of 6
Right,
years.
right,
So
right.
the winning of his appeal in Alberta, like, cut his time dramatically and got him the hell out of jail. So he got to run around Southern Ontario,
Right,
you know,
doing whatever,
doing
reports
whatever.
to, there would be a parole officer report
And
to
I,
make
you know
every
what,
couple of
I
weeks.
I don't want to go there, but I don't want to know what the fuck, whatever, because whatever the pedophile Sheppard is up to is not a good thing, and that's been proven time and time again. This one just happens to make the Supreme Court. Others languish in the background, but
Well, and
bottom line,
we have somebody who's been in denial about their offenses as well. And we have the offender being in denial about their offenses, and then having a whole bunch of other people saying, "We know you, you're a good guy. We believe that you've never done
I'm sorry, yeah, it's that's just fucking amazing to me that he got this. And the only possible just result from this case was the reinstitution of the remainder of his sentence. And lo and
anything." Right.
behold, it
That's what
was,
they
hey,
did.
asshole, report to your nearest jail, figure out how to get back into jail because that's where you're in. That's where
Right.
you are for now.
So what we have is they have this denunciation, which means you have to show to the community, correct? You have to say, look, when somebody's done this kind of stuff, we take it seriously, and this is the story. We're going to denounce it by symbolically showing you that we're taking it seriously by putting people in jail for this kind of behavior.
And you can't, I mean, yeah, and the rationale for the rejection of sentence was ridiculous. I mean, it was really, and it was just, it wasn't right. And we found ourselves in the midst of good citizens and government officials who took it upon themselves to right a wrong, to speak for a victim who really, I'm sure, feels completely disassociated in a lot of ways from this, but very associated. But watching this process go on, like it's not something within his control anymore.
No,
So they did the right fucking thing, and
they
kudos for
did.
that.
They came to what I think, and they look at this as like, would the average person see this as a positive outcome? The answer is yep.
Yep. And outcome for the future.
Yeah.
Right.
It sets precedent, as we said.
So, the final disposition of the case, they restored the original sentence, got him reincarcerated. The appeal, when I talk about the appeal, I'm talking about the appeal from the Crown prosecutor. They're the ones who complained about the sentence. And the pedophile Sheppard had to surrender to authorities.
Right.
Sweetest words I've heard in quite a while.
Yeah, they gave him, I can't remember what they said, but they said, he's got to report within X number of hours or something.
Yeah, it was 48 hours.
Yeah.
It
Which is generous, frankly. If he'd been in the courtroom itself, I think they might have just said, okay, come with us. But
they should just shove him over the border.
We still
He could
have we still have extradition treaties with most sensible countries so far, still with the United States. So
So anyway, bottom line, kudos to the Supreme Court. They did their job. I was proud to be a Canadian.
yeah, it's good.
Your tax dollars at work.
Well, and it also legitimizes and justifies the original prosecution, and you know, court proceedings do not solve what the victim, the individuals who've had sexual offenses done to them. They don't solve any of that, but it does say, yes, we believe you, and yes, we're taking it seriously. Is 6 years
Yes.
enough? Well, I have an opinion about offenders who have done this before, even if not convicted. We have a pattern of behavior with this man. Is 6 years enough? Well, in my opinion, I would say probably not. It needs to be monitored probably for the rest of his life, but we're
Well,
not in
let's
the
talk
business.
about that.
Yeah, we're not in the business of, yeah.
So much of this is repetitive. They allowed the appeal, they sentenced him to 6 years, they reincarcerated immediately. It reinforced the application of contemporary sentencing principles, Friesen, and it really upholds proportionality, parity, and denunciation in how you do sentencing.
Yeah.
Overall, what I said previously, the Supreme Court did the right thing. But one asks, is this story over?
And this is fascinating. Like, I don't know, I am saying fascinating. That's a mild word. It's jaw dropping.
So is perjury the next frontier, James?
So this is the Chief Justice, the head of the Supreme Court of Canada, who's talking to his lawyer, Brian Baresh, at the Supreme Court of Canada. He asked Mr. Baresh, who's a very well-known lawyer. He's got a national reputation. He asked Sheppard, did he have a prior criminal record? And says, Sheppard answered no. Is that perjury? And then I don't understand Mr. Baresh's response, which is, I suggest it isn't.
Well,
I don't know what this means. So
okay, I can give you the blow by blow here.
it sure sounds like it to the average person.
So basically, Sheppard failed to disclose a 1987 conviction in Ontario where he swatted the bare bottoms of underage boys while being a police officer. Jim, would you like to repeat that so it can sink into our audience, please?
A police officer catching kids doing maybe something that's criminal, maybe not, but decides that he's not going to take them down to the station, charge, take them home, do whatever it is that police officers do with young people who have done illegal things. He decides to pull down their pants and give them spankings on their bare bums. Unbelievable.
All the kids had single moms, by the way. So he was positioning himself as some sort of uber father figure, even at that time.
So consider single mothers in Canada in 1987. The typical situation here is they're not enforcing child support payments very well. So you have a mom who's having trouble parenting and working to support herself and children at the same time, even if there's some form of shared custody. And then you have somebody who's got a very good career as a police officer saying, I've decided to have pity on your child. They did this bad thing. I just gave them a spanking on their bare bum. Does this ingratiate him to the moms? And is he looking for single mothers to befriend because he could have access to their children? And I say this as a question, I don't know, but I'm also stating something that's an extremely common pattern. When I was doing parole assessments, I would have somebody who was charged with, he had befriended, developed a relationship with a woman, and started sexually offending against her children. And when we were doing assessments of these folks, we would go through their history exhaustively and find out who else there was. And there was generally a pattern stemming back to often early adulthood, And you'd see, you know, somebody who's in their early 20s often befriending somebody who was maybe 10 to 15 years older, who had children of the age that the offender preferred as their victims. You know, we don't know. But does it kind of lead my mind in that direction? Absolutely. I would, you know, I don't know. I'm needing to understand how this individual fits into typical normative. What I'm saying is typically encountered patterns of sexual offending. He didn't disclose it. Of course he didn't. We have a pro-social, you know, a fellow who presents himself well, ingratiates himself to the administration at school, ingratiates himself to everyone he meets, comes across as charming. He had a reference from an Alberta judge, even with this conviction, saying he was a good fellow. He's got a good way about him where he can convince people of all sorts of things that are frankly not true. He's a smooth talker, glib.
He's a pedophile. And 1987 had multiple children abused. And he was convicted and they let him off. And he went to Newfoundland and he got educated and got a few degrees in education.
So he's a smart individual. He's an intelligent person as well.
Exactly. And then he went to Ampleforth College,
which is what do we say? A highfalutin, a very good private school in the UK.
No, it's the Catholic Eton.
Right.
It's located in Yorkshire, near York, and it's been used in many of the Harry Potter movies. But it had it's run by Benedictine monks, or was, and has had a slew of scandals for, guess what? Beating children and sexually molesting them. So he went from 87 to 94 to that, came back after working there for a summer, with a letter from Ampleforth to St. John's of Alberta. They loved him, thought he was the greatest thing since, I mean, here was a man who was educated. Here was a man who had the paper to back it up. And what did St.
And
John's
had worked in a traditional Christian context.
The Catholic Eton of the goddamn world.
Okay.
Not just any school, the Catholic Eton. I mean, this is like, you know, being almost good enough to go to Eton, except you're Catholic, so you go to hell.
And just for those who don't know what Eton is this fancy school that if you go through the governing parties in the UK, all the ministers of everything, the prime ministers, all these people on all sides of the political equation there, whether they're Labour, Conservative, Lib Dem, whatever they are, they all went to these kinds of fancy schools.
And he had a recommendation from them after teaching there, running hell for a summer. And I mean, the story goes on and on and on, but the bottom line is this. When under trial for the case before the Supreme Court, in Alberta, he was asked, are there any other convictions? I mean, there's a transcript out there somewhere with him essentially denying any knowledge of any prior convictions before the years 2003, 2004. And he was asked, and he said no. He said no.
So that sounds like the standard textbook definition of perjury to a non-lawyer. I don't know. And then his lawyer says, "I suggest it isn't."
About it, James.
Why does his lawyer
doing about it?
And why does his lawyer suggest it isn't? Is that what the conclusion is? Oh, it wasn't because his lawyer said no?
I heard it, and he has a great lawyer. Somebody who, one of these classic curmudgeon lawyers who's been through everything. And the Baresh was dancing. He was dancing. He was answering the question any way he possibly could without being definitive in his answer. He knew. And he was just sort of throwing it out there as like, well, what the fuck does it mean? I suggest it isn't. He didn't back it up with anything. He didn't say, oh no, he never said that. He just said, I suggest it isn't.
Yeah, so it's
So
kind of it's kind of a way of saying I'm not really saying anything.
yeah, it's a way of,
It's a
I'm
no
not gonna,
comment. It's a no comment kind of way of going about it.
I'm not gonna risk my disbarment by
Right.
answering this honestly, Judge. Why are you putting me on the spot? That's basically the sense I
Wow.
got from it. But
Okay.
Wagner clearly states, what the fuck? And you know what? I've gotten emails from people and they're asking the same fucking thing.
So,
What the
so
fuck?
the question we have is there a court that's going to charge Mr. Sheppard, Paul Sheppard, with perjury?
Because he lied. I mean, he basically, think about it. What would you have done in terms as a sentencing judge if you would have known that he had been convicted in 1987?
You'd up the sentence.
Mm-hmm. Yeah,
You'd increase the sentence for sure. You know, instead of 6 years, it might have been 8, 10, 12. Who knows?
he'd served time
Because
for
there's
the
a
87 crime.
yes, but there is a pattern here, and it becomes more risky to the public that a person has done this before, and you're also hoping that a longer sentence will give the person time to get sex offender treatment and be rehabilitated so they don't do it again.
I submit that we're just scratching the surface of the multiple crimes of the pedophile Paul Sheppard. I submit that there are shit that we don't even know about because there's a period of his life where he taught internationally for years.
Okay.
I mean, God
So so
knows.
so
It's
so 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 what we've got is we've got him lying, and we've got a potential pattern that fits with normative patterns. So it's basically asking open questions right now, saying we don't know, but it sure looks bad.
it looks, I mean, the perjury thing, I don't see the issue. I mean, unless there's some kind of statute of limitation that I don't know about.
I don't
But to
think there
me,
is.
I don't know why there would be. This would have definitely influenced his sentence. I mean, it would have,
So
right? I
so,
mean,
so it would make sense that a crown prosecutor or whoever it is would say that this needs to be referred back to a court for decision.
but I wouldn't go, you know what? I would not go and try to mix it up in any kind of sexual stuff or any of his other crimes. If I were prosecuting it, it would basically be black and white, black or white. Either I have proof and it's documented somewhere that he
Right.
said this, or I don't. You're not going to,
Exactly.
convincing people isn't really the key.
No, there's
It's
nothing. Did he, in fact, does the transcript of the 1987 show that he lied? And
You mean the
now we're talking about.
so you're getting your
Yeah,
crimes mixed
yeah.
up
Sorry,
again.
but but but
It's
but
hard to do to keep straight for
it is.
years
But
straight
yes,
with this
does the
son of a
transcript
bitch.
of his St. John's School of Alberta offenses does that contain the statement that he didn't have any previous convictions, and then we have the Ontario conviction, so we know he's telling something that's completely false.
Actually, the trial occurred in 2021, I believe, during COVID. So my
Okay.
gut, if the trial occurred then there's for sure transcripts because it was a lot of it was done remotely. Well, I don't know, but I'm
We
sure
don't
there's
know. We don't
transcripts.
know.
There's
Yeah.
got to be transcripts if it's
What I'm aware
2021.
of in Canada is that they record a lot of stuff unless there's a reason to transcribe something. They often don't bother. It's just an expensive thing to do
What I
because
know
you can
about
get it done. You
Canada,
can get it done by the computer AI stuff, but then somebody still has to read it and make sure it's accurate.
what I know about Canada is everything's archived until it burns. Sadly,
Okay.
sadly, all that. I mean, people keep records. I don't know about that one. But anyway, my bottom line on this, and thank you so much for spending time today. But really, is perjury the next frontier? I mean, from my
I would think
perspective,
that it should, in the interest of simple justice, go forward. Like just as an average person, not exercising any professional opinion. I'm just saying, makes sense to me that they would go for it because it looks pretty simple.
could they? Is there any way? Okay, so there's two ways. To me, it's simple and send them away on perjury. Al Capone his ass. For all I care. I don't give a shit as long as he's off the street. Somebody like a monster like this shouldn't be on the street. I mean,
Well, that's
the
my
more,
opinion.
excuse me, the more I've researched it, the more I've read, the more it's not like you're telling me that somehow there's no recidivism on this, that somehow
Well,
magically.
let me just talk as somebody who's done, as over the course of my professional career, I've done a lot of things. And one thing I did is somewhere around 1,200 parole assessments. I don't even know the number. We don't count. Um, in Canada, we have two provisions for people who they get charged with something. They've been charged with previous things. There's a pattern in their life. The sentencing guidelines would say that maybe in this case, the person gets 6 years. What they have is additional provisions called long-term offender, which means that instead of, you've done your 6 years, you're done, they monitor you for an additional 10 years. And then they have a dangerous offender provision, which means they monitor and control you for life. And that means that you might be out, you might be in the joint, you might be in the prison, but they can monitor you forever. Put an ankle bracelet on you, do whatever it is that they want to do to keep your risk low, whatever you're doing, whether that's lockup or whether that's in the community under supervision. In my opinion, in the general circumstance of sexual offenses, we don't do that often enough. That where we monitor somebody, and I don't think 10 years for most people is what we should be doing. We should be monitoring for life, and we should have the capacity to take people and put them back into lockup when they look like they're at higher risk. That's my
Yeah, I
opinion.
don't know.
In the general situation, I would like to see law reform such that we don't allow people to repeat their sex crimes, because they hurt many more people and create lifetimes of suffering. That's where I'm at.
You and I have talked offline about this, but I've had lots of people who have related that, or maybe not. People kill themselves over shit like this, and they're victims.
That's correct. That's
and
correct. We actually have. If I go through the medical data about people who've experienced sexual offenses, the spin-off effects are individualized, of course, but I can list off the general things that happen. One is that they're at higher risk for all sorts of mood problems like depression and anxiety. They're at risk for disruption in their own relationships down the road, their relationships with their own children, their relationships with partners. They're at risk for disruption of their own sexual lives. They're at risk for an increase in medical problems of all kinds. The added stress within one's life that creates a background can predispose to everything. Worse outcomes for, you end up with a shoulder injury and you need surgery. If you've experienced sexual abuse, sexual assaults, your risk for more complications is increased. These are all just statistical indicators. If we can do anything in our society, it would be preventing sexual violence of all kinds. We mustn't have this. We cannot have people sexually assaulting other people and harming them. We just mustn't do that, and we must control this. And this is, part and parcel of being civilized human beings. Take others into account. And although individuals like Musk have said that empathy is ridiculous, or the recent whoever it was who got assassinated in the States said, empathy is an invented word. No, that's what makes us human. And I can't imagine we have St. John's, Christian, okay? Love one another as I have loved you. This is talking about the root word is not just feel love. It's about being kind and charitable towards others, taking into account others' feelings and being empathetic towards them and understanding the effects of your conduct on those other people. This is essential, and this is part and parcel of the core of what makes a society run properly and makes us equal and allows us to function in a normal kind of way. And I can't imagine, I think about the people who are advocating that, it didn't happen. The court of law has decided, and we're talking beyond a reasonable doubt. The bar is really high. It's not, I kind of think maybe it did. It happened. He did it. The kindness required of you out of Christian love is to
It's
say,
like
yes, it
this.
happened, and we're going to pay attention to it. Have the scales drop from, I'm dropping biblical references now, have the scales drop from your eye, see it clearly, through a glass clearly, not darkly, see it clearly, and understand that these things are extremely harmful, and that your role as somebody who understands this stuff is to sit down before the facts objectively, like a child saying, this happened, oh, there's a consequence for it, let's deal with it. Okay? Face up to the harm that you have done. St. John's, the context, harmed in general, and the specific behavior of some individuals harmed greatly. These are lessons and things that need to be taken into account. And it is completely inappropriate from any human perspective, religious, Christian, whatever it is, humane perspective, to ignore it and say, no, it's fine. It was okay. It made me a better person. BS. We don't accept it. It's nonsense.
Well, I think it was different for everybody, obviously, but what I don't like a lot is I went in 73 to 75 in Manitoba. And of course, the school wasn't that old yet. But the older the school got, the more it drew people like Sheppard. And let's be clear, I'm not accusing every master of being absolute pervert, like Paul, I shouldn't say monster, pedophile. And I call him a pedophile because he's a convicted pedophile. And
that's not controversial. That's not controversial.
There's no controversy there. And same with Mealy. And they, the school drew people like that later. There were people who were spank fetishists. This I know for a fact. I won't name them, but they were drawn to the school because of the SWAT regime. Now, what kind of low-life human are you? You and I went there because we were sent there.
Right.
We didn't enlist.
What you're talking is, and I'll say it a little bit differently. I'll say the question that needs to be addressed is, did the schools draw a subgroup of individuals who had psychiatric, behavioral, psychosexual, fetish, other kinds of disorders? Was there a subset? And is that a larger subset than there is in the general population? And the data appears to say
larger.
yes. Yeah,
absolutely larger, just because, it was like
could the schools have done more to prevent such things? Yeah. And now I'm talking about safeguarding, but I'm also talking about some contextual things, because the very structure of the school, as you have said quite eloquently, the very structure of the school was a magnet for individuals who subscribed to some of what the school, or all of what the schools stood for in terms of religious practice, getting back to what they considered to be basics, physical discipline, hitting children, punishing them severely, arduous physical wilderness trips, all of that, repeat the Voyager experience, all of those things to build character.
It's another podcast.
Yeah, but do we have a context in the school that inevitably leads in this direction? And I will say the sociological data from multiple places around the world says yes.
Screw that. I've experienced it. I've been like,
I'm talking as professionally as I can. As you know, and as everybody knows, I went to St. John's School of Alberta, 75, 76.
From a guy who had just been released from an institution in Ontario. There aren't many dealing with sexual predators. He never taught, but he hung out, and he got popped on something else. But he thought I was a teacher, because my name, English people, think that everybody named Pierre is the same person. Then this dude mistook me for another Pierre,
for someone else,
who was wrong, who I can't name, because there's nothing, who knows, right? But I mean, it's not like he hasn't been tried or anything, but I'm convinced they drew people are very like Sheppard's behavior. Let's say with you or I, the minute he knew that we were educated, I'm just saying, like, let's say he met us on the outside.
Yeah, he'd back off. He'd back off.
He wouldn't back off. He'd kiss our ass. And he'd
Okay.
make us feel very important. And he'd make us feel like what we say really fucking matters, as if it does. But he'd blow, you know, we'd get so much smoke blown up our asses that if we farted, the fire alarm would go off. How's that for metaphors? No, but he would really kiss our ass and ingratiate himself. Yeah. There is a word for that, ingratiate.
Quite possibly, quite possibly. But he had this, and I'm talking now as that pro-social, polished, sincere, glib way of presenting for himself. But and like he's probably a fellow who could make you feel instantly comfortable if you're just talking to him. He'd be probably great to have coffee with, and he probably is great still to have coffee with. He'd probably be a charming fellow to talk to.
He's like you or I,
right?
That way,
but.
That way, right? We get along. Right. We get along with everybody theoretically, except those who hate us.
Right, and then we have this whole dark side of sexual and you know, whatever sort of sexual / violent behavior combination that he has brewing inside of him. And then, of course, we're thinking about, so why do people, and this would be another podcast as well, but how is it that people turn into child-oriented sexual offenders? How does that happen?
Oh, I can't even, God knows. I mean,
and now I could talk for a year.
Yeah.
Because I can't completely explain, but I can explain partly. I can tell you what we know.
Is it genetic? Is it not?
Probably not. Probably not.
Learned?
Probably learned. And we talk about social learning, and then they talk about and then we talk about social contagion, which is this issue of having it done to you, or having observed it, or being brought up in a context which entitles you to think this way. It's like learning a language. If you're brought up in an English context, you speak English and understand it intuitively. If you're brought up in a Swahili environment, you understand that language. And you get introduced to a new language, and it's harder. But if you're introduced as young,
Quebecois, you know not to trust the fascist English.
There you go. There you go.
No, anyway, hockey season's starting.
Les Canadiens. Vive les Canadiens.
Another year. Actually, I like the Sharks.
Oh no.
The Sharks. The youngsters are getting older. They could get dangerous soon, but
most of us can't afford to go to an NHL game anymore. Okay, they're very expensive tickets. But I have seen in Winnipeg, and I've seen in Edmonton and Calgary. Montreal comes to town to play, and more people are cheering for Les Canadiens than they are cheering for the home team. Maybe not in Edmonton.
Well, that's like New York Yankees.
Right.
The Yankees, their fans follow them.
Except baseball's a terrible sport to watch. I hate it. It's better on TV because you can turn it off.
Another podcast. All right.
Another podcast.
Thanks so much. And we'll talk to you soon, everybody. Hopefully this didn't go too long, but I think it was definitely extremely interesting. So thank you again, Jim, for joining me, and we'll talk to you all soon.
It's always a pleasure, Pierre. Take care.
Bye.
Bye-bye.